Hi, everybody. I'm Samantha from the Law Offices of Samantha Wolfe. Thank you so much for joining us this month for our virtual seminar. As always, you can always check out our YouTube channel where we put all of our previous virtual seminars as well as some of our partnering with the pro videos. You can check out that as well. So thank you for coming. I'm going to have Jess start sharing our screen and we'll go ahead and get started. Just taking a minute. There we go.
Oh, do we need that? No, because we're not going to talk.
Okay, so the reason that we do our monthly virtual seminars is because we like to provide education as much as we can to clients and referral sources. So like I said, thank you for joining us. I was excited for this month. So we have marketing meetings where we meet every so often, my staff and I, and we kind of brainstorm new virtual seminar topics. And I will admit and apologize before we even start that this is a topic that I feel very passionately about. I'm pretty sure that especially Jess and Amy, who are sitting in the marketing meetings and our estate planning meetings, are tired of hearing me rant about this topic. So this particular seminar was something that came out of two personal experiences I had, one with a client and one actually with my grandmother. So I want to start off just talking a little bit about our situation, kind of the climate in Pennsylvania, how we handle our population as they age. So I have been experiencing some issues with some clients lately as they've been aging. And I will confess that I think that Pennsylvania and pretty much, all the United States does not really provide a way for our population to age with dignity. I feel like too often we're quick to say somebody's incapacitated, that they're not able to make decisions. And I really do feel like we need to be giving the respect and the opportunity for our aging population to be able to, as long as it's possible, to be able to have a say in their medical treatment, where they're at as far as staying at home or in a facility. And I know that that means that the younger generation needs to be more supportive. But as we've seen the nuclear family kind of spread out and maybe kids are farther away or aren't local, I feel like we're relying more on our systems, our government systems, to provide support for our aging population. And the problem with that is that we aren't getting necessarily the continuity of care. So for example, if I've had a longstanding client that I know and they're in a medical crisis and I kind of know their personality, know how they react, how they normally are when they're not in a crisis, it's much easier for me to weigh in on whether or not somebody actually is incapacitated or maybe has some limitations to their decision-making ability. But that's not usually the situation we're in. We're not usually in a situation where somebody has a longstanding relationship. More and more we're seeing where it's a physician in the hospital that may not know the patient that's weighing in on capacity. And so I think that what's happening is people are being deemed incapacitated or aren't giving the opportunity to weigh in on their healthcare decisions because it makes it easier for us as a society to be able to just say, well, this person's incapacitated. Let's go ahead and have their power of attorney making the decisions. And I know this probably isn't a popular thought. And again, my staff is tired of hearing me say it, but people can be fully capacitated and not make good decisions. I mean, I know I don't always make good decisions. I know that, my clients don't always make good decisions. So just because somebody is making a decision different than what we think, it doesn't automatically make them incapacitated. So I wanted to give you a little bit of that background because that's why I guess I feel so passionately about this topic, because I feel like as long as somebody is able to make the decision or at least contribute to the decision, then they need to be given that dignity and that honor to be able to weigh in. So with that being said, the goal of today's presentation is to try to educate a little bit more about the different types of healthcare documents that we can have and what we recommend and why we recommend them in certain situations. So a couple of months ago, my grandmother is in a facility. She's in an assisted living facility here locally. The facility's been fantastic. They've been wonderful. And I had actually been helping my grandmother get her documents in place. And my grandmother does have some issues with her memory. She repeats a lot of stories, but she still does have capacity. She has moments where it may not seem like she does, but she is, for the most part, able to make the majority of her decisions. And like I said, she's in an assisted living facility, and we had power of attorney documents in place for her. And what happened is that somebody from a healthcare provider here locally sent somebody in that does not have a medical degree and is not an attorney, and they met with her and talked to her about the Five Wishes document and whether or not she needed to sign that. They didn't ask if she already had a living will or a healthcare power of attorney. They just went ahead and actually discussed the Five Wishes document. And interestingly, kind of at the same time, I had clients reach out to me and they provided me with a copy of their Five Wishes document. And the way it arrived at the office was this medical worker, again, did not have a medical degree, was not an attorney, sent a cover letter with the Five Wishes documents and told me, please see the attached Five Wishes document. This is now the document that John and Jane Doe want as their healthcare proxy. And as I was looking through the document, my concern was that the Five Wishes document actually contradicted their living will document, which I had spent a good portion of time discussing with the client. And when they signed the Five Wishes document, they actually undid everything that they had previously decided in the living will, because the Five Wishes document says that it revokes any previous healthcare proxy that the client had in place. And my concern was that although this healthcare professional might have had the best interest of the client, I don't want to doubt their intentions. They actually created a situation where they had my client sign a new document without consulting with me as the attorney prior. And so when my grandmother I walked into her room and she had a Five Wishes document, it concerned me because I don't think that when medical professionals are talking to clients, I don't know that they're discussing all the legal ramifications with them. So I just wanted to, again, share all of this so that I can give some backstories to why we're going to go over that. So that being said, today we're going to talk about the importance of a living will and the difference between a living will, a POLST, and the Five Wishes document. So let's start with a chart. And we had the slide in there before because, again, it's like talking about apples and oranges. The documents are very different as to what they do, who should be signing them, at what stage of life you should be signing them. So what we have here is a chart. So we have a living will, a POLST, and the Five Wishes. An age requirement for a living will is anyone over the age of 18. That's the same with the Five Wishes document. A POLST operates a little bit different. It's for any age. Who can use it? It's for the living will, it's anyone regardless of their current health. So that's why we recommend all our clients to have a living will, because it's designed to cover any healthcare situation. And we're going to go over the specifics of a living will and talk about legally when it's effective. A POLST is anyone who is seriously ill or frail. The concern I have with a POLST is not whether or not you should have it. I think a POLST is a fantastic document to have. My preference and my recommendation for clients is not to execute a POLST until you do have some sort of diagnosis or you are at the period where you kind of have end of life wishes in mind. I had a situation where a client in her 50s who was otherwise really healthy other than being 50, which great health, no medications, all of that. And she had signed a POLST. And I was concerned about that because a POLST becomes a physician's order that is part of the client's chart, part of their medical record. And in most cases, you would want things like resuscitation or CPR if you're expected to make a recovery. So somebody in their 50s might not want to actually sign a POLST unless they do have some sort of terminal diagnosis or are seriously ill. Then they might want to consider a POLST. The Five Wishes would be for anyone who cannot make their own healthcare decisions. So again, you can use a Five Wishes document really in place place of a living will, but we're going to talk about why my preference is the living will. And I will tell you, a lot of it depends on what type of document the attorney is going to use. I feel like in Pennsylvania, we need to do a better job of trying to outline clients' wishes. So for example, I see a lot of clients come in and they may already have a living will, but there's like a list. It's like a checklist, and you go down and you say you do or do not want all of these different things. I might say CPR, breathing machine, dialysis, all of that. And you go down and you check, I do or do not want. The issue there is that a lot of times the documents aren't addressing things like if you would want pain relieving drugs being administered using an IV, or would you be okay with hydration if it's either A, used to deliver those pain relieving drugs, or B, to keep you hydrated so that you're not experiencing the symptoms of dehydration. So a lot of it when we're talking about this is in the context of if you have an attorney and a document that really outlines what you would want and is very specific, 9 times out of 10, your living will is going to provide more specifics of what you want than a 5 wishes document will. So anybody can do a 5 wishes. And if the choice is a 5 wishes document or nothing, then I'm always going to prefer the 5 wishes document. But I just think that a living will gives you more opportunity to state your preference under different circumstances. And I will go over it a little bit more because there's some dementia aspects that you want to make sure in the document as well. So when we get to the next category, a living will, a POLST, and a 5 wishes, it's a question of, does it tell the EMT in hospitals what medical treatment can be used in an emergency situation? And a living will typically does not. So a living will would be, usually you wouldn't necessarily give it to the EMTs or the ambulance people. You're really going to give it to the hospital staff or the physician who's treating the individual. That's typically who receives the living will. And usually, if you think about it, if you have a living will, but somebody has called the ambulance, then again, they're going to have to take the individual in because that's what they're required to do when somebody calls for an emergency responder. For a POLST, it would tell EMT and hospitals the medical treatment that can be used in an emergency situation because it's a physician's order that becomes part of your medical record. A 5 wishes document also does not tell the EMTs or the hospital any medical treatment that could be used in an emergency situation. So the only document that does that is the POLST, and that's because it's a physician's order. As far as guiding patient treatment when staying in a facility in a hospital, all 3 documents, the living will, the POLST, and the 5 wishes, does accomplish that. The next category is appointing someone to make healthcare decisions on your behalf. A living will does that. 5 wishes document does that. A POLST is typically where you're saying what you want and adopting it. So typically it's not saying, hey, go to this person and ask them what my preferences are under this circumstance. So hopefully this chart is helpful. If anybody wants a copy of the chart or even any of these PowerPoint slides after, you can just shoot Amy an email and she could get that to you. So a POLST is used as direct, immediate medical treatment. And usually when I've seen POLST, they're usually on like a bigger piece of paper, and it's usually like brightly colored. It could be green, that neon green. It could be like a bright yellow or a pink. And it's usually on a little bit thicker paper, like maybe a cardstock type of weight of a paper. And again, it's designed to be part of your medical record, where a living will is used for future decisions about medical treatments, meaning that typically a living will, we aren't actually in a crisis situation right now. Usually it's a document that's executed when the client is well, and it's just saying in the future, if these circumstances arise, this is how I would like my agent to handle decision-making powers and maybe even end-of-life decisions. Wanted to take a little break. We have a nice little comic here just to bring some lightness to the mood. So husband and wife, it looks like they're sitting on the couch, and husband says, just so you know, I never want to live in a vegetative state dependent on some machine. If that ever happens, just unplug me. And wife says, okay. And then there's the picture of the wife going up and unplugging the TV. So I thought that was funny. All right, so why is a living will important? So a living will does allow you to express your wishes in writing when you cannot physically express them. It provides clear instructions to the emergency medical staff, and the presence of a living will can provide your family with some relief and sense of direction. I want to pause on this point because I think this is actually the most important. Because what you have to understand about a living will in Pennsylvania is that a living will in Pennsylvania, the design is to say, this is the person who I want to make decisions if I am in a state where I cannot make the decisions. So, for example, if I executed a living will and I said, I want to appoint Jess, Jess is my sister, so it makes sense. So if I want to appoint Jess as my agent under my living will, then I might say, well, if I'm in a situation where I'm terminal and I cannot express my wishes, I'm okay with pain relieving drugs being administered, but maybe I don't want any life prolonging procedures. And I can outline all of that for Jess. But if there's any instance in which Jess is talking to the doctor and she's thinking, you know what, Sam would have wanted this type of treatment based on what the doctor is telling me, the living will does give her the ability to deviate from the document. And to me, that's the reason why the living will is so powerful and such a needed document, because I don't think we can anticipate every circumstance ever for every client. The best example would be the pandemic. We had a lot of clients that, didn't anticipate whether or not they would have to be on a ventilator. We had one client who needed to go on a ventilator because they had COVID, but they were able to recover and come off the ventilator. So the ventilator was used more as an opportunity for the lungs to heal from damage done by COVID. So, when I was talking with clients prior to 2020, I never said, if we're in a pandemic, are you okay with a ventilator? But what we did talk about is, do you want a breathing machine? Are you okay with a ventilator? And most of the time, clients would say, no, I don't want it. But in certain circumstances, like we saw with the pandemic, there might be circumstances in which the agent would want to consent to it. The other thing to remember is, if you have the ability to express your wishes to the physician, it is always what you want. So we actually had a lot of clients who were able to say, I'm okay going on the ventilator. They were actually able to consent to that because the doctor talked to them, told them all the risks, the reason they were doing it, and they actually consented to it. But I think the real power of the living will is that it does give the individual who you're appointing the discretion to make decisions based on what's happening and the medical circumstances which you're in. So I like the living will for that flexibility, as long as you're appointing somebody that you trust and that you trust the discretion that they would have. It really allows you to then cover any circumstance in which you would need a document. The other thing, before we switch to the POLST, that I want to talk about a living will is that a living will, we recommend that it discuss artificial hydration and nutrition, and that you actually treat them differently. So like I said, in our office, we typically recommend that your agent can consent to hydration or pain relieving drugs if it's used to keep you comfortable, and that would include an IV. But typically, clients don't want artificial nutrition. So when we have clients that come in with that check the box form, usually it says, I do or do not want artificial nutrition and or hydration. And I would prefer that it actually broke up those two categories. And most of the time, people are okay with hydration if it's used to keep you hydrated or if it's used to deliver those pain relieving drugs, but they don't want the artificial nutrition. So I actually like to break those two up. The other thing I like to do is I like to talk about what is considered life prolonging. So that can be everything from a breathing machine, CPR, dialysis, surgery, radiation, chemotherapy, antibiotics, or a feeding tube. Now, the antibiotics do trip people up a little bit because they're like, well, why wouldn't I want antibiotics? The best example I can give you is actually one from personal experience. My grandfather had COPD pretty bad at the time of his passing, and he would get pneumonia and not be able to clear it. So in the circumstance where he would be terminal with no realistic hope of recovery, and he was in a persistent vegetative state or a permanent state of unconsciousness, that's what the living will says, then it would give the agent the ability to say, I don't want antibiotic treatments if it's just prolonging his life. Meaning that if he'd had an infection that the antibiotics could clear, then they would give the antibiotics. But if it's something where he's on antibiotics and all it's doing is just keeping it so that he's living. And if he otherwise went off that, he would pass away from pneumonia. Then the living will would say, we don't want antibiotics under those circumstances. So I wanted to make sure to touch on that. The other thing I wanted to talk about is that in the living will, we do have provisions dealing with dementia or Alzheimer's, because that's not a terminal diagnosis. So in our document, we do include provisions that say if you get that diagnosis and the disease progresses to the point where you cannot swallow on your own, and we're talking swallowing, we're not talking about like the food swallowing, we're talking about the involuntary reflex of swallowing that you do all the time, that you don't even realize you're doing it. If the disease would progress to that point, that's when you want your end of life wishes to kick in, which means that, you wouldn't have a feeding tube, you just be given pain relieving drugs or hydration to keep you comfortable. So we do recommend that you have a provision specifically dealing with dementia or Alzheimer's in your documents. And the issue with some of the other documents, like maybe the Five Wishes, is that the Five Wishes document is intended to cover things like permanent brain damage or permanent state of unconsciousness, but it doesn't give you the flexibility to spell all of that out and say, under this circumstance, I'm okay, this, I don't want it. So that's why my preference is to have the living will. Plus, I do think having it as a document that an attorney drafts where you're able to talk about the legal ramifications of it and what does that mean, I think that's really helpful. The last thing I'll say about the living will is that in the living will, we typically recommend that if you have organ donation requests or cremation or burial wishes, that we actually include that in the living will and in the healthcare power of attorney. So that way your agent, when they're making decisions about life prolonging procedures or treatment, they know whether or not you do want organ donation. So our language, if someone wants organ donation, says, I want organ donation, and I understand that may mean that I have to be on life prolonging treatments in order to harvest the organs or harvest the tissue. And I'm okay with the life prolonging procedures during that time until they can retrieve those items or organs or tissues. So we typically like to have that language in there. We also like to specify whether you just want to donate major organs or tissues, because the default in Pennsylvania, even if you're an organ donor on your driver's license, is that's just major organs. That's not tissue, that's not cornea. So you may want to actually have a living will that spells out what your preferences are, so that if you are okay with things like tissue, we can put that in the document. So I wanted to make sure to mention that. The living will does also have a HIPAA release in there that just allows your agent access to your medical and hospital records, and really any information that would pertain to your treatment or healthcare needs. And so we make sure to put that in there as well. Now, going back to the POLST, POLST is an acronym that stands for Physician Orders for Life-Sustaining Treatment. And in Pennsylvania, it's shortened as the POLST. In Maryland, it's the MOLST. It's a medical form that's typically completed by a doctor, a nurse practitioner, or a physician's assistant in consultation with the patient. It allows people with serious or chronic illnesses or the frailties of age to spell out what kinds of medical care they would want to be given in any potential future medical emergency. And like I said, I think POLST are a great instrument to use. Sometimes I do think they're used prematurely and not in circumstances that deal with end of life or maybe chronic illnesses. And the example I can point to is that one with a client who was in her mid-50s who didn't actually need a POLST. So I wanted to make sure to mention that example, because if you are at the doctor and they're talking about a POLST, you can just provide them with a copy of your living will. That's usually they just want some sort of medical point person if you would ever be incapacitated. This, we took a picture of the Five Wishes document so you can see what the cover looks like. So this is what it looks like. On the first page, you typically print your name and your birth date. And then it's usually in like a pamphlet or a booklet type thing that allows you to specify your wishes. Let's go on to the next slide. This is the introduction that you see right inside the Five Wishes document, talking about what is the Five Wishes, how it can help, how does it affect your state, and how do you change it. Let's go finish going through what it looks like, and then we'll talk about that. So this does allow you to designate who you would appoint as your healthcare agent. But know that if you already have a healthcare power of attorney and a living will, and they're a solidly drafted document, you do not need a Five Wishes document. And if you sign it, it will supersede any living will or healthcare power of attorney that you have. So in the situation where my client had a living will and a healthcare power of attorney, then signed the Five Wishes document, if they wanted to go back to the document that we had originally discussed and they had executed, they would have to sign a new living will and a new healthcare power of attorney. This does talk a little bit about how do you pick the person that you're serving as your healthcare agent. Again, I think this is really important if we have individuals who don't want to go see an attorney or don't feel comfortable talking to a legal professional, because typically when I'm meeting with clients, if they don't have a strong opinion about who should serve, maybe they have 3 kids and they're not sure how to pick who they would serve, we do have a discussion about that. And sometimes we'll pick somebody, like if we have an individual that has 3 kids, we may appoint one individual as the agent, but then if they want to grant a HIPAA release that allows all of the kids to be able to talk to the doctor or receive medical information, we can do that in the document. So again, if you have a good legal professional who's talking to you about it, usually you can get the answers to these questions that they're alluding to in the 5 wishes, and that should be part of the discussion that you're having with your legal professional. The other thing that this is talking about is, what are your comfort wishes? How do you want people to treat you? What you want your loved ones to know? So it's more of a tutorial type of document that walks you through the stages of picking someone, how to decide what you want, but it doesn't really have the legal component as far as legally at what point are you under which document? How can I address this? Do I want tissues and major organs? None of that is going to be in the 5 wishes document. So when does the 5 wishes document take effect? So you will always make your own healthcare decisions if you're able to talk with the doctor and understand what's being said. The 5 wishes advance directive only takes effect when you're too ill to communicate to the physician or to the medical staff. If you're unable to make your own decision or speak for yourself, then your 5 wishes advance directive and the person you chose to be your agent can help and direct your care with a doctor. Now, like I said, I'm going through an experience now where a client did ask if I would serve as their healthcare agent. Didn't have a spouse, didn't have any surviving family members, so I did agree to serve in that capacity. The concern that I have is, even though in this particular situation, the medical professionals have determined that the client is incapacitated, I'm still able to talk to her. And when it came time to discuss facilities, I didn't want to make that decision independent from the client. So I actually had a conversation with her. Even though the medical professionals are telling me that she's unable to make decisions and doesn't have capacity to make the decisions, she's able to talk to me about the different facilities and what she wants. And just because the doctor is saying she doesn't have capacity and I have to sign everything, I want the client to be able to be joining in the decision and feel empowered to voice her opinion for as long as she's able to do that. So, if for some reason she would want to do something that would be harmful to her health, then I feel like maybe I'd handle a little bit differently. But, she's still very much taking a part in her medical decisions, and I want her to do that as long as she's able. I think too often we take that power away from somebody. And again, it's from a medical professional that's assessing her ability to make decisions. And that can be based on an isolated incident where different factors like being scared, being in an unfamiliar environment, not feeling comfortable with the person who's asking the questions, all of that affects how they're able to interact with the psychiatrist or the doctor who's making the assessment. And so again, I think that if you are appointed as the agent, I would still recommend that you consult with the principal. The principal's the person who appointed you, as much as you can, and make sure they're able to weigh in on the decision. Is the Five Wishes document a legal document? Yes. It was written with the help of the American Bar Association Commission on Law and Aging, and it does meet the legal requirements of 46 states, but it's used widely in all 50. And federal law does require medical care providers to honor the Five Wishes documents as they're expressed. And page 3 of the Five Wishes document does have advice on how to handle that. And the bottom line is follow the directions when you sign it. Now, I guess some of my concerns with the Five Wishes document is that it's written for all the states, right? It's designed to meet all of the state requirements, but each state actually treats things differently. And so again, my concern with the Five Wishes document is it specific to Pennsylvania? Does it address the difference between organ donation and tissue donation? Is that actually spelled out? And if it's not, then that's where a living will, I think, can be more detailed and more compliant with specific state law. Does the Five Wishes meet the HIPAA requirement? So what's interesting is when you're flipping through, you're not going to see a traditional HIPAA release in the document. So in our healthcare power of attorney and living will, I actually take language from the Healthcare Act that provided releases. It's the 1996 federal statute. It's shortened to HIPAA. I actually take a part of that and put it in the document. The Five Wishes document does not, but the Centers for Medicare and Medicaid Services, they have ruled that the agent or proxy appointed under the Five Wishes is treated as the patient's personal representative under HIPAA and has the same access to medical records and information as the patient once the advance directive takes effect. Now, again, if you're able to express what you want, then the Five Wishes isn't really in effect. So it's knowing the fact that the HIPAA release is not actually embedded in the Five Wishes document. The reason why there's a HIPAA release is because the Centers for Medicare and Medicaid Services are treating it as if it does have a HIPAA release. I'm a fan of actually having the release directly in the document. So how do you use the Five Wishes document? You take the following steps. You're going to review the document, possibly with your family. I would recommend that you do talk to an attorney, because even if you talk to the attorney and you still opt to do the Five Wishes document, at least you've had a discussion about the legal implications of the Five Wishes. And usually the attorney is going to talk about what's the difference between the Five Wishes and the living will. For the Five Wishes, you do need to fill it out in ink. You need to follow the directions to sign it. You want to discuss it with your healthcare agent and your doctor and give each of those individuals a copy of it. And you want to make sure a copy of your Five Wishes is placed in your medical file by your doctor, and you want to discuss it with family and friends. The other thing that the Five Wishes document does a little bit differently than, like, say, a living will or a healthcare power of attorney is sometimes we might name 3 individuals. So if we're dealing with a client that has 3 kids, we might name all 3 and say it's a decision of 2 out of the 3. And again, you don't have that flexibility in the Five Wishes document to be able to spell out how does the decision get made. Typically in a Five Wishes, you're going to say, this is my agent if they can't serve, it's this individual. If they can't serve, it's this individual. A living will gives you the flexibility if you wanted to say, well, I'm going to name 3, but if they can't agree, it's a majority rule. So again, I just think a living will gives you more flexibility. Does the Five Wishes document need to be notarized? If you live in North Carolina, South Carolina, West Virginia, or Missouri, you do have to have the Five Wishes document notarized. If you live in any other state, you don't have to have it notarized in order for it to be effective. But I'll tell you, in our office, whether it's a living will or any legal document, typically we're going to have it witnessed by 2 individuals and it be notarized. We do that for protective purposes. So the 2 witnesses are designed to say, yes, this person who's signing it is who they say, and same with the notary. So it's checking to make sure you had capacity and that you are who you say you are. In our office, our notaries do ask for a copy of like an ID, so typically a driver's license, or if an individual doesn't have a driver's license, maybe a state issued identification card of some sort, because then we're able to confirm that the person who's signing is actually who they say they are. And the witnesses, one of which is usually me, is saying that, yes, I had a conversation with the individual. They do have capacity. And Sometimes I'll get questioned by family members that will ask, what did you ask them to determine their capacity? There's no hard and fast rule about what I have to talk to the client about. Usually it's just a conversation where I'm not saying, who are you? What day is it? What year are we in? What month is it? I'm not asking those type of questions. Normally I can determine capacity by just having a conversation with the individual, talking about their family, what they've done the last week, what are their upcoming holiday plans. So just being able to place the fact that they know about what time of year it is, they know who their family members are, and they're able to orient themselves with what's happening in life. I will tell you a funny story because I was telling Jess this the other day. I was at a seminar at the beginning of November, and there was an attorney that was talking about how he determines capacity. And I thought this was fascinating because as another attorney, I'm always interested as to what other attorneys talk to their clients about. And he said he doesn't ask things like, what's the weather? What month is it? What year are we in? He asks one question, and that tells him whether or not the client has capacity. The question that he asks is, how do you feel about Donald Trump? And the reason he asks that is because it allows the individual to orient themselves, because Donald Trump has been around for a while. So are they talking about Donald Trump, the businessman? Are they talking about Donald Trump, the president? Are they talking about Donald Trump that's in the news, that's dealing with all the legal issues that he has? So he says, plus it's a fun topic because people usually have a very definitive response as to how they feel about Donald Trump. So just know that even if you're a family member or you're the person, just because the attorney's not asking the typical, who are you? What date is it? Where are we? It doesn't mean they're not assessing capacity. But I thought that was a fun way to determine if somebody was incapacitated. So, all right, Jess, let's continue on. So let's talk about a do not resuscitate order, or a DNR. So this is a little bit different than the POLST. So remember, a POLST is a physician's order that becomes part of your medical record. A DNR is similar, but it's specifically talking about a do not resuscitate order. And so we, in our living will, we have guidance about whether or not we want CPR, whether or not we want a breathing machine. The difference is a do not resuscitate order does become part of your medical record, and it's specific to resuscitation. It doesn't have all of the other stuff a POLST might have. It's a specific document dealing with individuals who are terminally ill and don't want to be brought back to life using CPR, defibrillation. Say that for me, Jess. Was it? Thank you. I can't pronounce it. Defibrillation. Thank you. With the paddles or other related options. So that would be a do not resuscitate order. So it's a little bit different than a POLST. All right, let me give you a hypothetical. I think we actually already talked about this when I was ranting and raving at the beginning, but Kathy and Joan Lance signed their healthcare power of attorney and their living will with their attorney. I actually went out to their facility. They were in an assisted living facility. We went out in the comfort of their own home. We had the discussion because I do think the best way to have this discussion is in an atmosphere in which you feel comfortable. And so sometimes, especially when we're talking about the living will and somebody's in a medical crisis, they feel more comfortable and they're better suited to make decisions if they feel more comfortable in their surroundings. So we typically try to go out to the facility. They had moved into an assisted living facility and signed the Five Wishes document. That then superseded their living will and their healthcare power of attorney. And it bothered me because, again, on the documents, it has my contact information, all of that. So I just wish that the individual that had met with them and counseled them about the Five Wishes document, I wish they had reached out to me so that I could be there to have that discussion with them. I don't mind that somebody wants to do a Five Wishes document as opposed to a living will or healthcare power of attorney. But I think we need to understand what are the legal ramifications if we do, and what does that mean? And in this case, the Five Wishes superseded our living will and healthcare power of attorney. Now, I did talk to the client and I said, this contradicts what you had originally said in your living will. Counseled them a little bit about it, and ultimately they decided to stay with the Five Wishes document, and that's perfectly fine. If that accomplishes what they want and they've changed their mind or they feel more comfortable with that, then they should stick with the Five Wishes. My concern is more of this needs to be a legal discussion. a medical discussion too, of course, but if we don't have a legal professional there, then there's nobody weighing in on the effectiveness and the legal ramifications of signing a new document.
Hold on.
Let's go to hypo 2. So hypo number 2 is a healthcare power of attorney and a living will. So this is something that we dealt with lately where it was a younger couple. They were late 30s, and unfortunately, husband had a terminal diagnosis, and he was receiving end-of-life care. And the question we got from the wife was, should I sign? They wanted her to sign a POLST. Should she sign the POLST as the agent under the living will? Because he had done a living will. And the reason that they wanted her to sign a POLST is because if EMTs or anybody was coming to the house to provide transportation or resuscitation for the husband, they wanted a POLST to be on record. And what I actually talked to the wife about is, in that case, I said, if you want to do a POLST, because that means that you can document the decision before you're in the middle of this crisis, then let's do a POLST. I said, but my concern with it is, if you're calling the EMTs, because in this case, they had brought in end-of-life care, hospice, that type of thing. If you're calling an EMT, what you're saying is, I want them to go to the hospital to seek further treatment. So in my opinion, the POLST really wasn't going to get them any farther, because if she's saying as the agent, I don't want any life prolonging treatment, and we already have hospice in there, then you're not calling the EMTs to come. That's not something that you're doing. You're handling it through hospice and home care. So in that case, I understood why the doctor had talked to her about a POLST, but I just felt like she still didn't need to sign a POLST. I felt like the living will still did what she wanted. And the other reason that I liked still using the living will is because it allowed her the ability to make the decision based on the circumstances. Now, again, for some people, they don't want that. They don't want to wait till they're in crisis. They want to be able to make the decision beforehand. But I just was looking at it from my perspective, which is, if I were her, I want to be able to make the call ultimately about what we're doing and when we're doing it. So we just talked to her about the ramifications about that. And I think ultimately, she decided just to keep him at home and keep using the living will as the document. But again, I didn't have a problem answering the questions, and I would have been okay had they wanted to do a POLST. But I just felt like, under the circumstances of that particular client, a POLST didn't really make sense, since we wanted to try to keep him at home and provide end-of-life care at home. Okay. So I know this was such a fun conversation to have on a Thursday over lunch, but like I said, it's a topic that I guess I'm feeling more and more passionate about as I represent clients that, as they age, are dealing with these situations. So I appreciate you guys listening. Hopefully this was helpful. Next month, we are doing a cybersecurity seminar. So it's going to be January 11th from 12 to 1. This one, I'll be live to introduce it, but I actually wanted the computer guy, I wanted to have it scheduled so that he could be able to get it on the books and record it. So we'll play it, and then I'll be happy to take any questions that anybody has after. But the reason I wanted to do this, talking about cybersecurity, is actually a personal story, which I will tell to open up the next cybersecurity virtual seminar on January 11th. But because you guys are here, you can hear my fun story now. My dad was at home, and he is the cook in our family. He loves to make the food. So he's getting ready for Thanksgiving, and he was looking up recipes for stuffing, because there's a big disagreement in our house about stuffing and how it should be made. So he's looking up recipes, and he clicked on a link, and all of a sudden his computer started making this siren noise. And my dad is very sensitive to loud noises, so it upset him a lot. And then he got a phone call from somebody, of course, saying they could shut off the siren for him if they just gave him his credit card information, all of that. My dad is not one to not take action. So he actually wrapped the laptop up in a towel and went out in the garage and took a hammer to the laptop. So that's how he chose to handle it. So it was perfect timing when I talked to Mike Cermak. He's going to be our guest with Cermak Technologies. And we talked to him about scams, fraud, how do we handle it if we do think that happened. And I do talk about my dad's situation and maybe what he could have done as opposed to taking a hammer to it. Now, don't worry, my dad is not without his computer. It made a great Christmas gift for us to get him because he's horrible to buy for. So don't worry, he already has his Christmas gift early and is still looking up all of those stuffing recipes that he loves. So join us on January 11th from 12 to 1, and we'll talk about cybersecurity, always on guard. You can respond or RSVP. You can email Amy at our office. You can call. You can also tell us that you want to join this seminar through our website. And we always record it. So if you're not able to make that day, you can either check it out on our YouTube channel or you can contact Amy. She'll get you the link for it. Okay, so I'm going to close us out and then I'll stop the recording and take any questions. So I just wanted to thank everybody. I'm Samantha with the Law Offices of Samantha Wolfe. Please know we always offer initial consultation, so you can call us at 717-655-2676 and we'd be happy to help you. Thank you so much for joining us. We hope to see you at next month's virtual seminar. Thank you.